arms up in the air. He never fired, right?
Correct.
It wasn't until you pointed your gun at him, advanced on him, with your gun, now your hands down, pointed at him, that he fired, right?
Correct.
The man shot by Rittenhouse and the star witness, apparently for the prosecution, appearing to undermine the case itself after testifying that Kyle Rittenhouse he did act in self-defense during last summer's BLM riots in Kenosha. That would be how you would interpret that.
Yeah. So now, where does the trial go from here? We are joined by criminal defense attorney Nicole DeBoard. Thank you very much for joining us, Nicole. So the prosecution has rested its case. How'd they do?
You know, not so great. This is not the only witness who seems to really offer defense testimony. Multiple witnesses testified for the prosecution that really did a whole lot more to solidify the idea that this was self-defense than it was any sort of a murder. So this was sort of the capstone. This witness really just tells the jury that he was not shot until he pointed a gun at Rittenhouse. And then that was essentially the end of the state's case. So they certainly did not end on a strong note.
Now, I haven't watched this all the way through, so you know it more than I do, but I do recall that there was the first shooting, which on video was in the distance. And there was somebody that appeared to throw like a plastic bag or something at Kyle Rittenhouse, and he responded by firing. This is not it, by the way, but there's other video that shows that. But then I think they had somebody testify that that person also went for Rittenhouse's gun. Maybe you can bring us up to date on that, because then that might also lend itself to the argument it was in self-defense.
That's exactly right. And there were a few unusual pieces to that testimony. One, there was some real concern and testimony that potentially there was something in the plastic bag that could have made the plastic bag a weapon that could have been swung at Rittenhouse or somebody else. So that's the first problem for the state. The second problem is exactly as you've described. It sounds like from the testimony that it's very much possible that Rittenhouse didn't fire until the person grabbed his gun, which would also really bolster the idea that this was self-defense behavior.
You know, Kyle Rittenhouse is now 18, but he was 17 at the time. He wasn't allowed to have a gun. He also took that gun across state lines. Does the defense need to address that? What does the defense need to do?
That's another great question. The reality is that's a totally separate charge.
Okay.
Whether or not he was in possession of the gun is potentially a crime. They really don't need to address that in this particular trial. It is a much less significant type of criminal charge. And there may not be a whole lot that they can do in terms of defense with that particular allegation. So the primary focus of this defense team, who has done a really fantastic job of highlighting their version of events, has been these murder allegations.
Nicole, from my knowledge of the way these criminal cases work, at this point in the trial, the defense would probably seek a motion to dismiss, making the argument that you haven't even made your case. Is that expected here? And if so, who makes that call? Does the judge decide whether to grant that?
I think the defense most certainly will make what we call a motion for directed verdict, asking the judge to decide the case based on what has been presented so far, on the idea that not enough evidence has been presented. The problem with that is that although the judge decides, the judge's hands are really tied. It's very difficult for a judge to grant, a motion for directed verdict or for an acquittal when there has been any evidence whatsoever presented by the state or the government that a crime has occurred. And in this case, even if just one person believes some piece of evidence that the prosecution presented, there's what we call a scintilla of evidence. So I think the judge is going to have a very hard time granting a motion for directed verdict in this case.
Yeah, and I know that it's not supposed to influence what happens in the court, but as we've seen recently, that's very difficult to stick with when you take into account responses from, say, social media and both mainstream media. My point being that Kyle Rittenhouse almost immediately was deemed to be guilty of murder in the social media sphere. So how do you think that will influence, or do you think it will influence what happens inside the court?
I think that it's always a concern, and the defense team has done, again, a fabulous job of highlighting, even through the prosecution's own witnesses, why the prosecution's theory fails and why the defense's theory is the one that should prevail. It is always difficult when there is sort of a massive amount of information out in the public, which really doesn't reflect all of what will ultimately come into play in trial, as has here. So it's a challenge, and certainly I would think that that would be on the court's mind, although the judge in this case has really kept this case moving down the middle, and I don't think that it would affect his rulings, but it's certainly always a concern.
Yeah.
Nicole, we only have about 10 seconds. I think Rittenhouse was supposed to testify. With what's happened, do you think he testifies or just stays off the stand?
Tough call, totally up to the client, of course. He may not need to.
Right, that's what I was wondering. It may have all changed. So, Nicole DeBoer, thank you.
Sure, thank you.
Hey, I'm Rob Finnerty. Thanks for watching. If you enjoyed this video, please join the conversation in the comments below. Don't forget to subscribe, too. Hit the bell icon to be alerted to breaking news. And remember, there's a whole lot more on Newsmax TV, America's fastest growing cable news network. Newsmax TV, we're real news for real people.